All right, guys. So last time we left off on slide 14, due process of law. So let's just start this conversation by talking about what exactly is due process. Due process describes the proper procedures designed to promote justice and protect the individual from the government. Due process is essential to guaranteeing fairness before the government may deprive a person of life, liberty, or property. So these are basically the procedural hoops that the government has to jump through before they can confine you or in some way take away a property right or other privilege. So usually when we're talking about an arrest, the first thing that's going to happen is going to be a search. So a search can happen in one of two ways. There can be probable cause for a search, which is just sufficient information to lead a reasonable person to believe that evidence is probably contained on the premises, and thus a warrant for the invasion of privacy is justified, or you can consent to that search. So let's pretend that you were pulled over in a vehicle. Let's say that your motor vehicle registration was expired. The police officer came up and they saw drug paraphernalia inside the car. Okay, well, that was in plain view. So now they have probable cause to believe that there is evidence of a crime that's probably contained within that car. Now, let's pretend that they didn't see any sort of evidence of that. They come up, they start talking to you, and they say, hey, can we search your car? If you say yes, that's another way that they get to go in and legally search it. Now let's pretend that they walked up, they didn't see any of the drug paraphernalia, and when they asked you for a consent search of the vehicle, you said no. Okay, let's say that they searched it anyway. If they searched it anyway and they found some type of drugs within the vehicle, then those drugs would be subject to something called the exclusionary rule. That's evidence resulting from unreasonable searches, and what that means is it's not admitted into court. So with the drug case that we were just talking about, maybe that one's not as big of a deal. But if the officers go in and they search your vehicle, and let's say they find evidence of a murder within that vehicle, if the search was illegal, meaning they didn't have probable cause or consent, then that evidence is not going to be able to come into court. And that's a really, really big deal. So why do we do that, even though sometimes the consequences are going to be really grave? Well, the fruits of that illegal search are called fruit of the poisonous tree. And the reason we do that is we want to make sure that the government really complies with all of the rights that are provided to you under the United States Constitution. So we put a really steep penalty if those rights are in some way violated. Now, that's a really sort of basic description for you. There's other ways to get around the probable cause requirement, but for the purposes of this course, you're going to need probable cause or you're going to need consent. So let's say that they found the cocaine totally validly. Okay, at that point, they're probably going to arrest you. And in an arrest, they're going to go through and they're going to read you your Miranda warning. Those warnings were established by a case called Miranda versus Arizona. And in that case, the court ruled that for a confession resulting from an interrogation to be valid, the prisoner would need to be reminded of certain rights in what came to be known as Miranda warning. So notice there that it's interrogation. It doesn't necessarily have to be read to you right when you're arrested. But before the police can start asking you questions about the crime, they have to go through and they have to read you certain rights. Again, there's going to be more than the rights that we're talking about here, but for purposes of this course, the Miranda warnings that you have to know are the ones that you're probably familiar with from like Law and Order or one of those other courtroom drama shows. So the first is going to be the suspect has the right to remain silent. The second is any statement made may be used against the suspect. And the third is the suspect has the right to an attorney, whether or not he or she can afford one. So in summary, what that's basically telling the defendant is it's probably in your best interest to stop talking and consult with counsel. So those are the 3 Miranda warnings that you're going to have to know for purposes of this class. Let's keep going through with our due process scenario. So you've been arrested, your Miranda warnings have been read to you. Next, we're going to go to arraignment. Arraignment is important because that's the first time that you're going to see a judge in your case. The judge, who is acting as a magistrate, is going to go through and read the charges that you're facing. This is basically designed to make sure that you understand why it is that you are currently being confined. They're also going to go through and remind you of those Miranda warnings, such as the right to an attorney, and bail will be set. So bail is a security deposit required for the release of a suspect awaiting trial. Remember that in the United States, you are innocent until proven guilty. So we have this presumption that we want you to be able to be out in society, functioning as a regular member of society, unless and until we find you guilty of some criminal offense. At the same time, we want to make sure that you show up for your court date. So we basically say if you don't show up, then that's going to be a big problem. You're going to lose this money. But assuming you can post this amount of money and assuming that you show up for your court date, we're going to let you go out into society and continue to function out there pending your trial. So arraignment is the first time you see the judge. Okay, what are the next steps that we're going to follow? The next steps have to deal with the grand jury. And remember that the grand jury are just those independent individuals who are convened to figure out whether or not there is sufficient evidence for you ever to be found guilty at trial. And remember, when we're talking about a grand jury, we're talking about those higher level criminal offenses. The right to a grand jury indictment is guaranteed in both the Texas and federal courts, and it's to protect the rights of innocent citizens, remember, against harassment or unjustified charges. So remember, it's really easy to get an indictment from that grand jury, but we're still going to make sure that we go through that hurdle, go through that step, so that we don't have any issues with somebody just being harassed with no evidence against them. So if that grand jury determines the existence of such evidence, the grand jury, remember, returns a true bill, which just approves an indictment. The indictment, remember, constitutes formal charges that enable the case to go to trial. Only rarely does a grand jury refuse to indict, and if they do refuse to indict, remember, they issue that no bill. Okay, so let's say that a true bill was issued. That means that due process rights are going to continue forward. If it was a no bill, then the proceedings would be over at that point. So let's say the grand jury issued a true bill. The next step is going to be something called pre-trial hearings. These are hearings that, like the name sounds like, are conducted prior to trial. And these could be things like a change of venue. So you feel like you can't get a fair shake in your regular community, and we need to move the trial somewhere else where we can have truly unbiased jurors. Okay, that would be done in a pretrial hearing. Or you think that certain evidence should be excluded. So like think back to that exclusionary rule that we were talking about before. You want to make sure that that cocaine doesn't come into the trial because you think that it was obtained illegally. Well, in that instance, your lawyer is going to ask for a pretrial hearing on that matter. Why is it important that we do some things prior to trial instead of during the course of a trial? Well, part of the reason is while the judge could give an instruction to the jury to disregard some piece of evidence that came in, it's really difficult for just normal human beings to go in and unsee something or unhear something. That doesn't really happen. So even if those jurors are acting to the best of their ability to disregard that evidence that came in that they weren't supposed to consider, it can probably still bias or taint the jury. So those pre-trial hearings are going to be an important part of the process. Now notice here, we've got the plea bargain. Plea bargains are not guaranteed, and remember that's just where the prosecution offers the defense a deal. They say, hey, plead guilty to this lesser level offense, and in exchange, we're going to recommend a lighter punishment for the defendant. So there's no guarantee that that offer will be made. That is not a due process right. But usually when we're looking at the shape and the scope of a criminal trial, usually that plea bargain is going to happen at this step in the process. Okay, so next we get to the trial, but remember that before we can have a trial, we're going to need to go in and convene a jury. Now, in order to figure out who's going to be on our jury, we're going to have this process called voir dire questioning, or if you're in Louisiana, it's called voir dire questioning. The same thing, it's just pronounced a little differently depending on your jurisdiction. That's basically the process where the prosecution and the defense team are going in and they are asking prospective jurors questions for the purpose of excluding jurors from the jury panel. So think back to those peremptory challenges and challenges for cause that we talked about before. That's going to be the type of questioning that's asked during that voir dire process. Okay, at this point, we're going to go to trial, and the trial is going to be conducted through an adversary system. An adversary system is just a legal system that's used in English-speaking countries in which two contesting parties present opposing views and evidence in a court of law. So the prosecution and the defense are basically pitted against each other. Both are trying to win. One of the problems that we see with our system is exactly this. The prosecution needs to hand over to the defense any information that would be considered what we call exculpatory, meaning that it tends to show that the defendant maybe didn't commit the crime. Well, the prosecution, even though they're obligated to do that under the law, they have a little bit of a vested interest in not turning that over, right? Because they really want to get a conviction. So we see some problems with our adversary system. Nonetheless, you see that in most common law countries. So most English law-speaking countries are going to have that adversary system. Okay. So we had the trial. Next, there's going to be a jury charge. So we don't just send the jury back and say, tell us whether or not you think this individual is guilty or not guilty of possession of the cocaine. They're going to need a little bit more guidance than that. Because what if there were two individuals in the car? What if you were traveling with somebody? And what if the cocaine was in your vehicle, but in the passenger seat where the other person could reach it? Okay, well, is that in your possession or control? We look to the law to figure out, what does that mean? What does possession or control mean? So we're sending the jury back with instructions. That's going to be the jury charge. From that, the jury is going to return a verdict. That verdict is either going to be guilty or not guilty. If the verdict is not guilty, remember, our process is going to stop there. But what if it's guilty? Well, at that point, we're going to go through and we're going to have a sentence imposed. The sentence can be imposed by either a jury or the judge, and there are going to be various sentences that could be proposed. So remember, we've talked about this previously, but this is just going a little bit more in depth. You could go in as the judge or as the jury and sentence the defendant to probation. So probation is a judge's sentence allowing an offender to serve time outside of a correctional institution, but under specific restrictions. So oftentimes it'll be under the supervision of a probation officer. You might need to go in and do random drug tests. Potentially you'll have to go and get full-time employment or be enrolled full-time in school. You might need to meet some other types of conditions, such as picking a residence within a certain jurisdiction and staying there. There might be travel restrictions that are imposed on you. So the actual probation itself is going to look different for each individual offender, but it's an option that's there instead of confining somebody. So this is kind of useful for two reasons. Number one, it's obviously useful for the defendant, but number two, for society as a whole, it actually costs us less money to have people on probation than have them incarcerated. Of course, if they screw up under the terms of their probation, then they'll go to jail. Okay, so we went through the trial, we had a verdict, we had a sentence. Next up, we're going to have the post-trial proceedings. Those post-trial proceedings are the appeals process. So think back to those courts of appellate jurisdiction that we talked about in Chapter 9. You've got those 14 regional courts of appeal, and then you've got the Texas Court of Criminal Appeals and the Texas Supreme Court. So when we talk about the appeals process, remember we're in one of those courts. So if the defendant is found guilty, obviously the defendant can appeal. Oh, but we talked about double jeopardy before. The state cannot appeal a not guilty verdict because, remember, doing so would constitute double jeopardy. However, prosecutors may appeal the reversal of a guilty verdict by a higher court. Misdemeanor cases from justice of the peace and municipal courts may be either appealed or completely retried. Remember, we talked about that. Those were de novo trials in the county court. Appeals from the county and district courts, remember, go to one of the 14 courts of appeals, and finally up to the Texas Court of Criminal Appeals if it's a criminal case. The one exception to that is going to be what? Death penalty cases, right? In a death penalty cases, we don't go to those regional courts of appeals first. Instead, we go straight up to the Texas Court of Criminal Appeals. Okay, so what about juveniles? We've talked about juveniles previously for a very brief period of time, but understand that for juveniles, you're actually only considered a juvenile automatically if you're 16 or below. So for criminal sentencing purposes, we consider you to be an adult at the age of 17. Juvenile proceedings are special civil procedures. So we seal those records, and also there's different types of punishment for juveniles than adults. We think of juveniles as being not fully formed really developmentally yet in terms of brain cognition, and so we give them a little bit more of a break, and we think that potentially there's a little bit greater chance for reform. Now, we said that 16 and below we're going to consider a juvenile, unless, though, you have committed a serious offense. Serious offenders who are over the age of 13 may stand criminal trial as adults. So, if we've got a juvenile who's gone in and committed something really serious, some felony level offense, then they can be certified to stand trial as an adult at 14 or above. Felony punishments, we talked about probation already. Prison is going to be where you go for a felony. Jail is where you go for a misdemeanor. Parole is going to look similar to probation in that it's basically supervised release. However, with parole, you have an initial stay in prison. So prisoners are just serving the remainder of their sentences under supervision in the community. And that supervision oftentimes tends to look a lot like what we see with probation. It's just that at first, these individuals were incarcerated. but they got out early based on good behavior, contributions that they made to their prison community, etc. Clemency was talked about before when we talked about Chapter 8. So if you'll recall Chapter 8, remember there's the Texas Board of Pardons and Parole. And the Texas Board of Pardons and Paroles is in charge of making a recommendation with regards to clemency, which, as you'll recall, is just a form of mercy. It's up to the governor then to actually sign off on that recommended clemency. Remember, the governor can always sign off or deny the clemency, but can't give greater clemency than that which was recommended by the Texas Board of Pardons and Parole. Kind of a little self-check that we put within the executive branch. So, what are some different types of clemency? Well, there's a pardon, which is designed to absolve a citizen from the legal consequences of his or her crime. Really famous example of a pardon, that would be President Nixon. So even if we all kind of commonly acknowledge that this individual probably committed an offense and that otherwise this individual would be eligible to receive sentencing and serve that sentencing, a pardon basically goes in and excuses any of the legal consequences that would occur from that defendant's conduct. Commutation of sentence. This is just a reduction in punishment. So we saw this not too long ago, about a year ago in Texas. Governor Greg Abbott went in and commuted an individual sentence who had killed pretty much his entire family and tried to kill his dad, but his dad survived. And that individual, the defendant, was sentenced to death. The defendant's father went in and urged the state to commute his son's sentence over to life in prison. So Governor Abbott agreed, and that's an example that you see of a commutation of sentence. You're still going to be punished, you're just going to be punished less severely than what you were originally sentenced for. So instead of the death penalty, it's life in prison, or instead of life in prison, it's 30 years with the possibility of parole. Anytime we're talking about a reduction in punishment, that's a commutation of sentence. Reprieve is going to be another type of clemency. Reprieve is a temporary interruption of punishment. You see this most often in death penalty cases. You'll see a reprieve of 30 days granted because maybe some new evidence has come to light. And with that new evidence, maybe we need to give the court system a chance to go and look into that. So we don't want to execute somebody if there's any sort of doubt as to whether or not that individual is actually guilty of the crime. If new evidence occurs, then the governor can sign off on this temporary reprieve. So what are some of the different reasons that we go in and we punish individuals? Well, Texas jails and penitentiaries are intended to have several functions. Number one, they're supposed to provide justice. Justice, when we think about that, is really this idea of social vengeance. It's a society's way of settling accounts with those who have violated its norms. The concept of justice normally requires that the punishment should fit the crime. So if somebody comes in and they steal your car and they wreck it, and then you no longer have a car, and you've got to pay out of pocket a certain amount in your deductible, or you have to pay to get a new car, whatever, you probably want to see some level of punishment for that individual, because in your mind, that's probably the only way for there to be any sort of accountability or justice in the system. It also serves the premise of isolation. Isolation of criminals from law-abiding populations is designed to protect society from future crimes. Yet for most crimes, society is unwilling to prescribe the permanent imprisonment of convicted criminals. So the idea is we want to keep individuals who are likely to reoffend, particularly for serious offenses, away from other people. Obviously, there needs to be some balancing there. The person who stole the car probably doesn't deserve to be in prison for the rest of their life, because society probably doesn't need for them to be isolated away from them for that long of a period of time. The third use is going to be deterrence. Deterrence of criminals is society's effort at discouraging criminal behavior by threat of punishment. Society uses punishment of convicted criminals as an example to discourage would-be lawbreakers. So it's this idea that, let's say you kill somebody and we put you in prison for the rest of your life. Well, the idea is we want other people to see that and say, oh, I would like to not be in prison for the rest of my life, so I'm not going to go and kill someone. That feels reasonable. That would be an example of deterrence. Rehabilitation is the last one. Rehabilitation of convicted criminals is supposed to allow those who are ultimately released to take useful and non-criminal roles in society. The effort is to correct criminals' antisocial attitudes and behavior. So the idea behind rehabilitation is we're trying to stop something called recidivism. Recidivism is when we have somebody coming in and repeating their offenses over and over. So recidivists are repeat offenders who have relapsed into crime. Now, when we look at those 4 different functions, honestly, most of what we're going to be dealing with is the justice one, the idea of social vengeance. That is, for the most part, how we have gone in and structured our criminal justice system. It does have elements of all of the rest of these, but when we look at it more in depth, we see that really it's usually not designed to isolate fully, because there's usually, like we talked about with the car example, we're not really going to throw people in prison for the rest of their lives for most offenses. So at some point, we're going to be okay with this idea of these offenders coming back out into society. Deterrence, studies have shown that it's very rare that criminals actually think through the long-term consequences of their actions, and you can see this play out in death penalty states. States with the death penalty actually tend to see a larger number of capital crimes than what you see in other states that don't have the death penalty, which is the opposite of what we would expect to see if deterrence was really a true motivation. Rehabilitation, we do have some rehabilitation programs in prisons. It's going to depend on the individual prison, exactly what all is provided. But generally speaking, we provide vocational classes, sometimes GED classes as well. But in terms of long-term improvement, like making sure that we're consistently holding AA meetings and NA meetings, and that we're doing individual and group counseling and trying to decrease the amount of recidivism, we really don't see that as much in our society as you do in other societies. Most European countries, their primary emphasis is on rehabilitation. For us, most of our emphasis is on this idea of justice. Neither is necessarily right or wrong. It's just 2 different ways of doing things. Okay. And so when we were talking about that death penalty and how it doesn't necessarily decrease serious offenses, you can kind of see an example of this with the FBI index crime rates per 100,000. So all in dark red, those are the states that have the highest rate of FBI index crimes, which, remember, we said tend to be those more serious offenses that are either violent in nature or have the propensity to become violent in nature. So you can see here that states that have capital punishment and tend to give increased time for offenses tend to have actual higher FBI index crime rates. Now, originally, a lot of people will say, well, yeah, but Texas has a lot of people. Well, notice that that's actually controlled. That's a controlled study based on population size. So it's rate per 100,000 in the population. So we've already gone in and controlled for the size of the population. Okay, and finally, rehabilitation and punishment. We probably are not looking too much at rehabilitation when we have the death penalty, because as we all know, what that's really designed to accomplish is punishment. We're obviously not looking to rehabilitate people when we're going in and executing them. The case for the death penalty in large part has to do with this idea of punishment or social vengeance. If somebody's family member has been killed in a really heinous way, or somebody's gone out and killed a whole lot of people, it's pretty understandable that that individual wants to see some sort of compensatory justice. If we look at the case against it, though, like we talked about earlier, we tend to not see a decrease in crime rate. Actually, in states that have the death penalty, we see an increase in the crime rate. The other problem that we tend to see with death penalty states as well, in addition to the fact that you've got really no deterrent factor there, is that you spend a lot more money on individuals if you sentence them to death, which I know sounds kind of counterintuitive, but there's a lot that goes into keeping somebody on death row. We have to make sure that that person has an attorney and has the right to the full appellate process, both on the state level and on the federal level. Because remember, just because somebody is convicted of a crime does not mean that their due process rights stop there. So that process can be very expensive. The drugs necessary that we need to get in order to execute someone can also be relatively expensive. We've got to have all kinds of mechanisms in place. We need to pay oftentimes to get the victims there, to actually be able to see that individual be executed. There's a lot of costs associated with the death penalty. Again, it's not that either perspective is right or wrong. Those are just the two perspectives that you need to know and that are highlighted in your textbook. So that's the end of Chapter 10. If you have any questions, please feel free to let me know. As always, you can email or we can set up an individual Blackboard Collaborate session. And other than that, you're pretty close to being done. So let me know if you have any questions. Thanks. Bye.